10 seconds, 5 seconds, start. Moreover, the relief claimed for by the plaintiff in the applications under consideration would on its strict construction be found even beyond the scope of the suit. Learned counsel appearing for the defendant argued that failure on the part of the plaintiff to take remedial measures for removing the legal defects in the plant despite a specific objection in that regard taken in the written statement by the defendant further would show that conduct of the plaintiff prior to the institution of the suit was not quite desirable. In order to tilt the balance of convenience in favor of the plaintiff has to show existence of a prima facie case, likelihood of serious prejudice or irretrievable injustice to the plaintiff and status of the defendant in relation to the property in dispute. These aspects of the case, examined from any point of view, would not indicate that the plaintiff has a good prima facie case. For the reasons aforestated, there is no merit in the application filed by the plaintiff under Order 39, Rules 1 and 2, and as such the same is dismissed. Consequently, injunction order dated 25th July 2005 is vacated. The application is disposed of while leaving the parties to bear their own cost. One of the main objectives of enactment on arbitration and conciliation is to minimize the supervisory role of the courts in arbitral process. The statement of objects and reasons emphasized the objective of minimization of the interference of the courts in arbitration process. In accordance with the provisions of the Act, the interference of the courts is very limited in matters relating to arbitration except in specified circumstances. Courts do not come in the way of arbitration matters at all from the commencement of arbitration proceedings till the arbitral award is made. Section 5 of the Act provides for the extent of judicial intervention, which says that notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. The words used are judicial authority, which is a wider term than the word court. Therefore, the judicial intervention has been restricted and minimized. The judicial authority's intervention under the Act is limited to the processes as prescribed by the Act itself. Power to refer parties to arbitration where there is an arbitration agreement rests with the judicial authority, which is a wider term and includes court. This is one of the important provisions since it encourages parties to go in for arbitration instead of resorting to settle the matters through courts. If any of the parties to the arbitration agreement approaches the court without referring its matter to the arbitrator in spite of the existence of arbitration agreement, the other party can make an application to the court and the court can pass order to refer the parties to arbitration.